Judgment in the matter of Byers and others against the Saudi National Bank.
Lord Briggs will hand down the judgment.
This appeal raises a point of some general importance to equity lawyers, but which needs a little unpacking for it to be generally intelligible. Trust property is property of any kind to which one person or group, the trustees, have legal title as against all the world, but in which another person or group, the beneficiaries, have the beneficial ownership in the form of an equitable interest in the property. Trustees are liable to account to the beneficiaries for their stewardship of the trust property. The rights of the beneficiaries, in particular trust property, may be overreached where the trustee has power under the terms of the trust to dispose of the property, usually by sale. Generally, however, the rights of the beneficiaries continue to subsist in the trust property if it is transferred or disposed of by the trustee acting in breach of trust. The beneficiaries can demand that the property be returned to them or to a new trustee to hold for them. That is called a proprietary claim and is based on the beneficiary's continuing equitable interest in the trust property. Whoever then has legal title to the trust property must hand it back. But sometimes the person, whom I will call D, to whom the trust property has been transferred by the trustees acting in breach of trust, disposes of it or dissipates it in such a way that the beneficiary's equitable proprietary interest in the property is destroyed. The beneficiaries can no longer demand the return of the property from anyone. But equity comes to their aid by treating D as personally liable to the beneficiaries in what is called knowing receipt, so that D must account to the beneficiaries for his stewardship of the property as if D had been a trustee of it from the moment when D received it. So if D destroys or dissipates the property, D must pay the beneficiaries an amount equivalent to its value. The liability is called knowing receipt because it only affects D from the moment when D knows about the beneficiary's rights in relation to the property. Sometimes D is immune from knowing receipt liability. The best example is where D has bought the legal title to the property from the trustee for full value and without notice of the beneficiary's rights. D bought the property in good faith to become its beneficial owner, and equity regards such a purchaser as having a better right to beneficial ownership than the original beneficiaries. D is treated as having clean title to the property, free from any claims of the beneficiaries, whose only claims lie against their trustee for disposing of the property in breach of trust. Their interests in the trust property are said to have been overridden by the sale to D. The question in the present appeal is whether a foreign law governing the disposal of the trust property, which is designed to give someone who takes a transfer of the property a clean title, even if that person received it knowing of the beneficiary's rights and knowing that the transfer was in breach of trust, makes that person immune from a claim in knowing receipt by the beneficiaries. The facts of the case are these. Between 2002 and 2008, a Mr. Al-Sanea came to hold blocks of shares in 5 Saudi Arabian companies on trust for Saad Investments Company Limited, which I'll call Saad, under a trust governed by the law of the Cayman Islands, which for all relevant purposes is the same as English law. In September 2009, acting in breach of trust, Mr. Al-Sanea transferred all the shares to a finance company, Samba Financial Group, I'll call Samba, in settlement of very large debts which he personally owed Samba. At the time of the transfer of the shares, Samba knew that they were held on trust for Saad and also knew or should have realized that their transfer to Samba was a grave breach of trust by Mr. Al-Sanea. But Saudi law provides that a registered transfer of shares in a Saudi company gives clean title to the transferee, free from any beneficial interests under a trust. Saad has since become insolvent and is represented by its liquidator, Mr. Byers. Samba has passed the shares on to the Saudi National Bank as part of a corporate reorganization, but this doesn't affect any claim which Saad may have. It's now agreed that the registered transfer of the shares to Samba did override Saad's beneficial interest in the shares, so that it can no longer demand them back by means of a proprietary claim. But Mr. Byers says that this did not destroy Saad's personal claim against Samba in knowing receipt. Samba knew about Saad's beneficial interest and knew that Mr. Al-Sanea had transferred the shares in breach of trust. Samba, and now therefore the Saudi National Bank, say that the effect of the destruction of Saad's beneficial interest in the shares by the transfer to Samba was also to destroy any claim in knowing receipt. The outcome of the case turns on this general question of law. Does a claim in knowing receipt depend upon the claimant beneficiaries still having a proprietary interest in the trust property at the time when it was received by the defendant? For Saad, it is said that a claim in knowing receipt, as an equitable claim, depends only on it being shown to be unconscionable for the defendant to retain the property for its own benefit. It is not at all dependent on the beneficiaries having a continuing equitable interest in the property at the time of its receipt by the defendant. The claim, said Mr. Byers, need have no continuing proprietary base. Both the trial judge, Mr. Justice Fancourt, and the Court of Appeal, Lord Justices Newey, Lady Justice Asplin, and Lord Justice Popplewell, concluded that a claim in knowing receipt did depend upon there being a continued proprietary base, so that it failed because the effect of the transfer of the shares under Saudi law was to destroy Saad's beneficial interest in the shares when transferred to Samba. Mr. Byers and his co-liquidator now appeal to the Supreme Court. We unanimously agree with the courts below. Lord Burrows and I give full separate judgments to substantially the same effect, with which Lords Hodge, Lord Leggett and Lord Stevens agree. Our central reasons are in summary as follows. 1. There is a deep-rooted contradiction between recognising that the defendant has been given clean title to the property and at the same time being under a liability to account for the stewardship of it to someone else, which is what knowing receipt liability amounts to. 2. There's a serious lack of logic in the view that where a beneficial interest is overridden so as to prevent a proprietary claim, nonetheless a beneficiary can pursue a personal claim with the same object of getting back the property or its value. 3. There is a significant difference between the equitable wrong of dishonest assistance in a breach of trust and liability for knowing receipt, and it's therefore irrelevant that the former does not require that the beneficiary has a continuing proprietary interest in the property. 4. In the absence of any original fiduciary relationship between the beneficiaries and the defendant, or other relationship giving rise to equitable obligations between them, there is no reason why a transferee with a clear title should be subject to any equitable obligation or liability to the beneficiaries. And 5, a failure to give full effect to applicable foreign law, here the law of Saudi Arabia, which confers clean title to property governed by that law, would show a lack of respect for the primacy of that foreign law in relation to the relevant property. Lord Burrows also reasons that knowing receipt should best be regarded as a species of equitable proprietary wrong, analogous to the tort of conversion, but without strict liability, which cannot survive the destruction of the claimant's equitable proprietary interest in the property, other than that a destruction wrought by the defendant. The liability is constituted by the defendant knowingly interfering with the equitable proprietary rights of the claimant. Both Lord Burrows and I conduct a detailed review of the relevant authorities on knowing receipt. Although not of decisive force, we both conclude that those authorities tend to support the conclusion which we have both reached as a matter of principle. Both of us also consider the application of knowing receipt to the analogous situation of directors acting in breach of fiduciary duty to their company, and Lord Burrows further considers the relationship between knowing receipt and contractual principles. The appeal is therefore dismissed.
Thank you.